And welcome back to Afford Law. At Afford Law, we practice criminal and family law in Massachusetts. On today's topic, we're going to be addressing restraining orders and harassment prevention orders in Massachusetts. Before we get started, I just want to take a moment to explain exactly how we work things at Afford Law. At Afford Law, as I said, we practice criminal and family law. Family law basically is divorce, child custody, child support, all that kind of stuff. And we practice our whole reason for being is that we're trying to make ourselves as affordable as possible to reach out to those folks who can't afford an attorney on the open market, but do not qualify for court-appointed assistance. So we use a sliding scale based on our client's income. So the less you make, the less we charge for our services. So let's take a look at restraining orders and harassment prevention orders in Massachusetts. So there are two types of restraining orders, just using that term broadly. There are restraining orders, which is under 209A, that's the statute, and there are harassment prevention orders under, I think, Section 258. So what to keep in mind is the main difference between these two is who can qualify for each of them. A harassment prevention order is available to anyone, regardless of their relationship with the person that they're trying to get the order against. On restraining orders, basically the other person needs the two of you have had to have been in a significant dating relationship or have a close personal contact such as that. So harassment prevention orders are, as I said, are for everybody. So as far as the process goes, it's very similar. You go into the court and apply for the order. So you go to the civil clerk's office and you get a packet of paperwork that needs to be filled out. I think there are 4 forms that need to be filled out, basically giving your information. You are the plaintiff. You give the defendant's information. That's the person against whom you're trying to get the order, and then some other type information. Probably the most important is the affidavit. The affidavit is a document, a sworn document. So you are swearing that the information that you're providing on that document is true and accurate, and basically you spell out what's going on and what brings you to the court to try to ask for the order. In a harassment prevention order, you need to have 3 separate incidences of an event causing harassment. So it has to be 3 individual times that you can point to the court where this person is harassing you. So things such as yelling at you, swearing at you, calling you names, or bad-mouthing you on social media are terrible things, perhaps, but those probably don't rise to the level of harassment. Typically, harassment are incessant phone calls. So phone call after blowing up your phone. It could be an event of one event of harassment if it's within a period of time. So let's just say a person calls you constantly for 2 hours on one night. That could be one incident of harassment. Stalking you certainly is a form of harassment. So if somebody's following you home from work, if somebody follows you to work, if somebody shows up at your work and wants to know where you've been, what's going on, that could be an incident of harassment. And any threats, if somebody threatens you physically, I'm going to get you, I'm going to beat you up, or whatever that might be, that too is one particular incident of harassment that would qualify you to get a harassment prevention order. A 209A order or a restraining order, you don't need 3 separate events. But basically what you're telling the court is that you are in fear of your physical safety from this person. The court will want to know if that person has a history of violence against you or other people. Have they threatened violence against you in the past? If you're on a 209A, oftentimes there is a dating relationship or marriage or a child that's in common. So oftentimes you and the other person have a history, rather than with the harassment prevention order, you don't have to have a history, certainly not a close history like that. So for a harassment prevention orders, oftentimes neighbors will seek harassment prevention orders against their neighbor. So you fill out the paperwork, you give that back to the clerk, and you wait to be heard before the judge. So you're going in on what they call an ex parte hearing. Ex parte just means one party. You're going in without the other person being present. The judge will listen to you and will ask questions of you. Basically, they want to know why you are there, asking for the order, whichever one it is. They have the affidavit. They will have read that, and then they want to ask questions, perhaps follow-up questions, to get a clearer understanding of what exactly has been going on in your situation. So the judge will get all that information. So particularly with harassment prevention orders, you want to be clear. You want to be prepared to say on a particular, if you can, on a particular date, which is even better. If not, at least narrow it down as reasonably as possible. On this particular date, this person did this to me, followed me at work or contacted me in a threatening manner or something along those lines. So you need 3 separate incidents, and if without the 3, the judge will not issue an order. With a 209A or a restraining order, you want to indicate to the judge why you are in fear of your safety. This person has hurt me in the past and has threatened me with further harm, or this person has threatened me with physical harm, and I believe that they will carry out that threat. So the judge will make a determination. At that time, the judge will make a determination whether a temporary order will be issued. The temporary order will be in place for a period of time, and you will need to come back for a 2-party hearing. So what happens is in the interim, the order is in place. The police will have to go out and serve the other party because they may not be aware that there's an order in place. So the other party will be served by the police, and they will be notified of the next court date for the 2-party hearing. They can be present, and they can basically tell their side of the story and explain why they believe that the order should not issue, if that's the case. So in all things in the justice system, a person needs to have notice, to be put on notice that something's going on, and the opportunity to be heard. And that's what the 2-party hearing is all about. So at the 2-party hearing, it's similar to the ex parte hearing, but it's a little different because the 2 parties are there. You may want to call, you certainly would want to be able to call any witnesses that will support your side of the story. The other person may bring in witnesses or documents or whatever to present their side of the story. So you want to have your evidence ready to go to present before the judge. The 2 parties will have their opportunity to speak to the judge. If there are any witnesses, that witness will testify. That witness is subject to cross-examine. So if the other side brings in somebody, say a family member who's saying something happened different from the way that you're saying that it happened, you have the opportunity to cross-examine that. That means ask them questions, make them answer under oath, and try to get to the bottom of the matter, to get to the truth. So the hearing will take place, and a judge will decide whether you have met your burden, because you have the burden of proof, whether or not that burden of proof has been met, and the order will be continued. And the order can be continued for up to 1 year. And at the end of that 1 year, at the 1-year date, if you want it extended beyond that date, you need to show up on that date at the time that the court will give you, so that you can once again ask the court to extend the order, just as you did in this place, at this location. So if the other party doesn't show up for the 2-party hearing, then the order will be typically the order is almost always extended for the year. Keep in mind that at the 2-party hearing, the other person doesn't have to show up. The order will probably be extended if they don't, but you need to be there. If you're not there for the 2-party hearing, the judge will, in all likelihood, not extend the order, and the order will expire at the end of the business day that day, so 4:30 or so in the afternoon. So also keep in mind that to get a restraining order or a harassment prevention order, that order is civil in nature. So that means basically that just means it's not a criminal matter. It doesn't go on somebody's criminal record, although it is included in their Board of Probation record if anybody ever pulls that up. It's not a crime, however, but a violation of an order, either one of those, is a crime. So if somebody has been, if an order has entered against someone and that person has been served a copy or at least been put on notice that the order is in place, and let's say the order says um, that they are not to contact you. If they call you up, that's a violation of the order, and they could be charged, and they most likely will be charged with a violation of that 209A order. Um, so the order can include many things. It can have a no contact with you. That, and no contact means exactly that. It means to have no contact with you in person, on the phone, through social media, texts, whatever, and also not through a third party. So the other person can't tell your sister to relay a message to you, for example. So a no contact order is typically in place. Oftentimes the person is told not to get within a certain physical location of you, so that they have to stay 100 yards away from you, for instance. A judge can either not grant that or grant that and make a different physical location if they so choose. So in particular, we see this with neighbors, 100 yards. If you're living next door to somebody, you cannot stay 100 yards apart. So the judge may modify the order to make it 3 yards or 3 feet. Well, not 3 yards, 3 yards typically. So you have a sort of a zone of protection, if you will. So there are other things that can be included in that. When they're not to come to your work, they are not to come to your home, and so forth. The judge has a lot of discretion in deciding what exactly he or she wants to enter into the order. With orders also, they can, if there are children involved, the judge can order temporary custody of the child to go with you rather than the other party. And this is a way to get in quickly to a court to establish custody. We often see orders being used in district court, people availing themselves of that rather than family court, and they may have family court issues, but a district court is a way to get a restraining order and temporary custody of a child or children on a very quick basis. So that's the sort of the rundown with restraining orders and with harassment prevention orders. Again, at Afford Law, we always charge our clients on a sliding scale. We charge a fee based on our client's income. So the less you make, the less we charge, basically. We're trying to make ourselves as affordable as possible to the working men and women of Massachusetts, because after all, they deserve a break as well. The folks that have no money can get legal aid or a court-appointed attorney, and people with money can go out and hire whoever they want. Our concern is what happens to the people in the middle, and that's who we're trying to represent, and proud to do so, if I may say. So thank you very much for joining us. If you have any questions about this or any other family law or criminal law question, we'd be happy to answer. Please feel free to visit us at affordlaw.org. Check out our resources. There's a lot of information there. At Afford Law, we're making justice affordable. Thank you.